This section covers appeals of administrative decisions in section 1248 of the Denver Zoning Code. This section is relevant to any action of CPD staff. Any order, requirement, decision, determination, or permit may be appealed to the Board of Adjustment. The appeal must be filed with the Board of Adjustment within 30 days of the action. Appeals shall be filed in writing and must specify the particular grounds upon which the appeal is taken. That means that the appellant must specify how they believe that CPD erred in the action taken. The fees must be paid at the time of the application, and all fees are set and collected by the Board of Adjustment. Upon appeal, all actions that further what's being appealed shall be stayed or paused unless the zoning administrator certifies that a stay would cause unnecessary or undue risk of damage or disruption to life or property, or would conflict with efforts to address a public health emergency. For example, if a delay in the middle of construction activities would leave the site vulnerable to destruction by weather or for other safety reasons, then the ZA can certify as such and the construction can proceed to make the site safe. When the zoning administrator certifies as much, the only option for pausing the proceedings in furtherance of the action would be a restraining order issued by a court. Letter D here, action by the zoning administrator, requires that the zoning administrator transmit all documents and materials that make up the record upon which the order or decision was based. The new text requires that the zoning administrator transmit that full record within 21 days from the date when a complete administrative appeal is submitted to the Board of Adjustment. And that's one quick aside here on the 21 calendar day deadline. It might be important to note that Division 13.2 states that if the 21st day falls on a Saturday, Sunday, or legal holiday, the period extends to the next day that's not a Saturday, Sunday, or a holiday. So while these subsections did not change in the bundle for a public hearing and decision by the Board of Adjustment or the presumption and review criteria, it's important for anyone handling an appeal or submitting an appeal to know that any order or decision by an administrative official is presumed to be correct unless clear and convincing evidence is introduced before the Board of Adjustment that supports a contrary determination or finding. Clear and convincing evidence is a legal standard that requires evidence to be highly probable and substantially more likely to be true than not. It's a higher standard of proof than the preponderance of evidence, which is what's required for approval of other discretionary actions in the code. And finally, it's also important to note that when someone appeals a decision of the zoning administrator or staff, they must get the vote of 4 members of the Board of Adjustment to reverse any order, decision, or determination.